Anthony Esan, you may remain seated until I tell you to stand up. I must sentence you now in relation to 3 offences, 1 count of attempted murder and 2 counts of possession of a bladed article in a public place. All of these offences arise out of a single incident. On the 23rd of July 2024 at 1750 hours, Lieutenant Colonel Mark Teeton, the Chief Instructor in the Professional Engineering Wing, working at the Brompton Barracks in Kent, left work to walk home dressed in full uniform, boots and beret, and carrying a backpack. Unbeknown to Mr. Teeton, you had, shortly afterwards, at 1752 hours, parked your moped at the top of Sally Port, the road where he lived. You took off your motorcycle helmet, but kept your balaclava on. You opened the box compartment of the moped and took 2 knives out of it, leaving other knives that you had purchased a few days before in the box compartment. A minute later, at 1753 hours, Mr. Teeton passed you. You spoke to him as he did so, asking him if you could have his mobile telephone, lying to Mr. Teeton that your moped had broken down and that you needed to call someone to come and help. Mr. Teeton, who was concerned that you might try to steal his mobile telephone, said that he would put the number into his mobile telephone himself. As he started to do this, you moved towards Mr. Teeton, stabbing out at him repeatedly. Mr. Teeton shouted out "police" and kicked out with his legs to defend himself, managing to get to his feet and move off. You pursued him down the road and began stabbing him again, using the 2 knives as you set about Mr. Teeton's head and neck area. Mr. Teeton was on the ground being attacked by you when Mr. Teeton's wife, Eileen Teeton, came out of their home address having heard shouts for help. You continued to attack Mr. Teeton, stabbing him again and again. Mrs. Teeton only realized that it was her husband who was being attacked when she got right next to you. Her actions were remarkable. CCTV footage showing her on the telephone to the police whilst also trying to pull you away from her husband. She described the attack as follows. The male turned back towards Mark and bent over him. From his bending position, he started pushing his knife towards Mark's face and neck, making short, pushing motions, as if he was trying to get the blade in the exact place that he wanted it. I would describe it as if he was trying to carve Mark's face. Mrs. Teeton was clear that your movements as you were attacking her husband were deliberate and not frenzied. You then walked off. I am satisfied that this was because you must have concluded that you had killed Mr. Teeton. You got back onto your moped, put your helmet back on and drove off, leaving one of your shoes and the 2 knives at the scene. You drove home, arriving there by 1810 hours. 7 minutes later, witnesses having provided the police with the registration number of the moped, you were arrested. As the police officers searched you, you referred to the devil, to Enoch, and said, 365 is the day of the devil. This is for Enoch, karma, and this is for the inaudible, that's happened in my country. You also made the following comment, cyberpunk, have you not heard of it? Enoch, have you not heard of Enoch? 365 in the year, have you not heard of that? You were then taken to a police station and put into a cell. During this period, you were asked for the PIN to your mobile telephone. You refused to give it. You became abusive towards officers and threw a drink at one of them. You were taken to an interview room where you said, "Is this where I get to make my offer?" You were uncooperative with your solicitor and the police officers thereafter, and so it was not possible to conduct an interview with you. On more than one occasion, you asked police officers if you were on the news. After you were charged with the offence of attempted murder, you asked, "Am I free now?" Mr. Teeton sustained multiple stab wounds across his body. His injuries were life-threatening. The fact that he did not die has rightly been described as miraculous, given their number, location, and the force with which they were inflicted. Having been treated at the scene by paramedics, an air ambulance was deployed and arrived at 1828 hours. Mr. Teeton was transferred to King's College Hospital for treatment, where he remained for a prolonged period. As Mr. Barraclough, King's Counsel, on your behalf, rightly put it, this was a most appalling attack on a serving soldier. The horror of the attack is unimaginable. The court has heard eloquent and moving statements from Mr. Teeton and Mrs. Teeton, and has read no less eloquent and moving statements from their two daughters, Emily and Hannah. The dignity and courage shown by the whole family has been nothing short of remarkable. There was never any doubt that you were the person who attacked Mr. Teeton. It was therefore inevitable that you would be facing a count of attempted murder. It was not, however, until the 8th of January 2026, a year after this matter was originally due to come to trial, that you pleaded guilty to that offence, as well as the 2 counts of having an article with a bladed point. The delay came about because it was not until the 3rd of September 2025 that you were deemed fit to plead. The 3 psychiatric experts, Dr. Nabby and Dr. Alcock, instructed on your behalf, and Professor Blackwood, instructed by the prosecution, all concluding that this is the position. It was on this basis that it was determined by the court at a hearing on the 3rd of September 2025 that you should be arraigned on the 27th of November 2025. In the event, however, at the hearing on the 27th November 2025, it was indicated that you were not providing instructions, and further concern was expressed as to your fitness to plead. This resulted in an adjournment which Mrs. Teeton described as leaving her feeling completely devastated, with her expectations that the family could move on shattered. Further assessments were then conducted by Dr. Alcock and Dr. Nabby in early January, which confirmed that you are fit to plead, leading you ultimately during the course of the hearing on the 8th of January 2026 and following further consultation time to enter guilty pleas. I turn against this background to the sentencing framework within which I am required to approach the matter of sentence in your case. The starting point is the Sentencing Council's sentencing offenders with mental disorders, developmental disorders, or neurological disorders guideline, which both the prosecution and the defence acknowledge is applicable in your case in view of the fact that all 3 experts agree that, as I shall come on to address in more detail later, you suffer from schizophrenia. This guideline notes at paragraph 6 that the sentencing judge should make an initial assessment of culpability in accordance with any relevant offence-specific guideline before then considering whether culpability was reduced as a risk of reoccurrence. This means that concerns about a scenario where you might not take medication are of limited significance, since, if there is a significant risk, including a risk presented by your failure to take medication, then it is difficult to imagine how, in the Section 45A context, a future parole board would conclude that you should be released. I am clear that the particular circumstances of this case and its gravity are such that your state of mental health and arrangements to monitor you would receive the most careful attention in the event that you are being considered for release. In this respect, it should furthermore be borne in mind that conditions can be imposed on a life license, and by which multi-agency public protection arrangements should follow for effective protections. It is not, therefore, the case that if released into the community, you would be in an unrestricted and unsupported position, since, on the contrary, release would only be countenanced if safeguards are able to be put in place so as to mean that you are not in an unrestricted and unsupported position. I do not, therefore, accept that in practical terms the position would be so starkly different if an order is made under Section 45A compared with the position were a Section 37/41 order to be made. It follows that the concerns expressed by the experts are not ones which, in my judgment, should mean that a Section 45A order is not made in your case, notwithstanding the conclusion which I have reached concerning your level of culpability and the need for there to be a penal aspect to the disposal in your case. I am accordingly satisfied on the evidence in the particular circumstances of this case, and for the reasons I have given, that the appropriate disposal in your case is an order under Section 45A of the 1983 Act, namely a sentence for imprisonment, with a direction that you are detained in hospital rather than in prison for as long as it is necessary that you be detained in hospital. In the light of this, I must now return to the attempted murder guidelines, starting with step 1. I have previously touched on this, but it is clear that yours is a Category D, lesser culpability case, because your responsibility is substantially reduced by mental disorder. Miss Morgan accepted that this is the position, just as Mr. Barraclough acknowledged that in terms of harm, the offence falls into Category 1. What you did to Mr. Teeton was deeply traumatic for him, his wife and family. It has caused considerable and ongoing trauma for them all. It has altered Mr. Teeton's ability to perform his employment. It has led to significant lifestyle changes for the whole family. Mr. Teeton is permanently scarred as a result of the wounds that were inflicted, albeit ongoing physical consequences are thankfully limited. Step 2 involves the court looking at the starting point identified in the guideline for a Category D1 offence and reaching a sentence within the category range by adjusting the starting point upwards or downwards as may be necessary to reflect particular features of culpability and or harm. The starting point identified in the guideline for a Category D1 offence is 14 years imprisonment, with a sentencing range of 10 to 20 years imprisonment. Mr. Barraclough submits that your mental disorder means that your offence should be treated as coming at the bottom of that 10 to 20 year category range. However, since the fact that Category D includes a case where an offender's responsibility is substantially reduced by mental disorder, and that there is a starting point of 14 years, this means that Mr. Barraclough cannot be right about this. What the court is required to do nonetheless is to have regard to whether there are factors which mean that there should be a further upward or downward adjustment. As for the relevant factors increasing seriousness, which are listed in the guideline, there are 2 factors of relevance. The first is the fact that the offence was committed against a person working in the public sector or providing a service to the public. The second is the fact that others were put at risk of harm by the offence, most notably Mrs. Teeton, but also other people who came upon the scene as you were attacking Mr. Teeton in the street. As for the factors reducing seriousness or reflecting personal mitigation, which are listed in the guideline, there are 2 which are relevant, bearing in mind that your mental disorder has already been taken into account as part of step 1. First, the fact that you have no previous convictions, though it is clear that you have possessed knives previously. And secondly, your relatively young age. I am clear that the aggravating factors substantially outweigh the mitigating factors. This leads me to conclude that there should be a significant increase from the 14-year starting point to a notional sentence prior to credit for guilty plea and subject to step 5 of 18 years imprisonment. This brings me to step 4, namely the appropriate reduction that should be made to reflect the fact that you have pleaded guilty to the attempted murder offence. In this respect, I have had regard to the Sentencing Council's reduction in sentence for a guilty plea guideline. Since you did not enter a guilty plea at the first stage of proceedings, which I take to be the hearing which was listed for the 27th of November 2025, and instead waited until the hearing on the 8th of January 2026 before deciding to plead guilty, the appropriate reduction for guilty plea is 25% rather than the 1/3, which would have been available had you pleaded guilty on the 27th of November 2025. As a result, the notional 18-year sentence prior to credit for guilty plea is, subject to step 5, reduced to 13 years and 6 months imprisonment. Turning to step 5, this requires the court to consider the matter of dangerousness and specifically whether it is appropriate that there be a life sentence. I am entirely satisfied that this is the position in your case. Having regard to Section 285 of the Sentencing Act 2020, you present a significant risk to members of the public of serious harm occasioned by the commission of further specified offences, and the seriousness of the offence for which I am sentencing you is such as to justify the imposition of a life sentence. The minimum term is calculated by reducing the 13 years and 6 months notional determinate sentence to which I have referred by 1/3 to reflect the fact that you would have been entitled to be released at the 2/3 point of that determinate sentence had it been the sentence imposed on you. Accordingly, the minimum term is 9 years imprisonment, from which will be deducted the 568 days which you have already spent on remand in custody, so that the minimum term which you will serve is 7 years and 162 days. I should lastly deal with the two offences of possession of a bladed article in a public place, namely the knives that you used in the attack on Mr. Teeton. These are offences in respect of which the maximum sentence is 4 years imprisonment, and in respect of which the Sentencing Council has published a guideline. Applying that guideline, I am satisfied that the offences fall into category A2 and so have a starting point of 6 months imprisonment with a sentencing range of 3 months to 1 year's imprisonment. Concurrent sentences of 6 months imprisonment would be appropriate in your case, each of those sentences being made concurrent with the sentence in respect of the attempted murder count. Please stand. For the offence of attempted murder, I sentence you to life imprisonment with a minimum term of 7 years and 162 days imprisonment. And I direct, under the provisions of Section 45A of the Mental Health Act 1983, that in the light of the psychiatric evidence, namely Professor Blackwood, Dr. Nabi and Dr. Alcock, the criteria for a hospital order are met. And so instead of being removed to and detained in a prison, you will be readmitted to and detained at Broadmoor High Security Hospital. You will be subject to the special restrictions set out in Section 41 of the Mental Health Act 1983. What this means is that you will be detained in hospital for as long as necessary. If and when it is no longer necessary, you will be transferred to prison. Once in prison, you will serve the remainder of the sentence which I have imposed. As for the minimum term which I have identified, this is the minimum term which you will serve in custody before the parole board may first consider your possible release. The parole board will then decide whether you can leave custody at that stage, and if so, on what terms. If you are refused parole at that time, you will remain in custody, subject to regular reviews by the parole board. If and when you are released, you will be on license for the rest of your life. If you break the terms of your license, you will be liable to return to custody. In addition to the conditions on your license, you will also be subject to the conditions of your release from hospital. As for the 2 counts of possession of a bladed article in a public place, you are sentenced to 6 months imprisonment in respect of each of these counts, each of those sentences being made concurrent with the sentence in respect of the attempted murder count. You will also have to pay the statutory surcharge. Go with the officers.